Naila Abdul Aziz and my fellow friends. Before we begin, let me introduce myself briefly. I am Jayshree Jayendaram and my group members are Kirtika, Kausalya, Sandhya and Felicia will be presiding today on the topic of nuisance, which is under the topic of law of thought. Let's start with introduction. The word nuisance literally means annoyance or any source of inconvenience. Ordinarily, nuisance means disturbances. Branch of law of thought that concern with protection of private right in the enjoyment of land. In law, nuisance signifies, according to Blackstone, anything that causes hurt, inconvenience or damage. Nuisance is an unlawful interference with a person's use or enjoyment of land or some right over in connection with it. It involves a substantial, unreasonable and repeated or continuous interference by the person with the use or enjoyment of property which cause inconvenience to either individuals or public. Nuisance may refer to such irritants as noxious smells, noise, smoke, unattended savaging around a neighborhood, indecent signs and pictures on businesses, obstruction of public highway, noise from industrial installations, keeping dogs that bark all night, and a house of bothersome activities. Next, essential elements of nuisance. Wrongful act by the defendant. For the action against nuisance to arise, the first essentially is the conduct of a wrongful act by the defendant. This may include any action which is prima facie not legal and unreasonable in the eyes of a prudent man. Next, damage or loss or inconvenience caused to the plaintiff. Actually, nuisance as a thought is further categorized into two types such as public nuisance and private nuisance. Let's first start with public nuisance. Public nuisance is an unreasonable, unwarranted or unlawful interference with a right common to the general public. Simply speaking, a public nuisance is an act affecting the public at large or some considerable portion of it, and it must be interfere with rights which members of the community might otherwise enjoy. In addition, public nuisance is primarily a criminal offence and so is prosecuted by the state, but a private individual who has suffered special damage as a result of such nuisance may bring an action in tort. Instances of public nuisance include obstruction of highway or public roads, public waterways, noises, pollution, oil spillage from the activities of multinational oil companies, and etc. An example case of public nuisance is Pacific Engineering versus Haji Ahmad Rice Mill 1966. This case is about the plaintiff carries on the businesses of selling construction equipment and machinery. The party has from the defendant's factory had discussed with the plaintiff's factory and caused the plaintiff's employees to cover their mouths and noses. When there is a wind, the flying rice husk also causes the door of the premises to be closed. Plaintiff's equipment and machinery become dusty and the lubricating oil become dirty. To conclude, in this case, the plaintiff had proved that they suffered personal discomfort and injury to property there by satisfying the requirement special damage. An injunction preventing the defendant from the burning rice husk in the compound of their premises was granted. The court held that action for public nuisance, a plaintiff may institute proceeding without obtaining prior consent from the AG if he suffered special damage.
Hello everyone, I am Sandhya. The second type of nuisance is private nuisance. Well, private nuisance is one of the portion in law of thought. Private nuisance may be described as unlawful interference with a person, use or enjoyment Sustainable Hut, which held 2002. There was a material and physical damage to the land and the property. The defendant owned a hotel that consists 20 stores. Plaintiff claimed the building works of defendant as caused serve cracks to their heritage buildings. The court held plaintiff as right to injunction as physical damage to property constitutes substantial interference. In addition, the damages of private nuisance are in the case of damages to property, and any sensible injury will be sufficient to support an action. Nuisance of this case arise from manufacturing goods, chains, for example, smoke, fumes, gas, noise, water, animals. Damages are only available once the damages has occurred. The physical damages must be established substantial in the nature, and it appears that what amounts to substantial interference is also a question of fact and determinable on a case-by-case basis.
Good day to Madam Shahila. My name is Kirtika Pedalwar. Today I will explain about the remedies and the difference between public and private. Now let's move on to the remedies. Commonly, monetary damages are used to compensate for nuisance. Under some condition, an injunction or abandonment may be also appropriate. An injunction directs a defendant to stop, remove, restrain and restrict a nuisance or to abandon intention to create the future nuisance. In public nuisance proceeding, a fine or imprisonment as well as abandon or injunction remedies may be issued. Injunctions are severe remedies that should only be utilized when the remedies endanger irreversible and cannot be adequately compensated by monetary damages. Self-help remedies abandoned by the plaintiff is available. This privilege must be involved within a reasonable time after learning of the nuisance, and usually necessities be employed, and the plaintiff may be accountable for unreasonable or unnecessary damages. For example, if dead tree limbs are reaching dangerous over neighbor's house, the neighbors is may remove them after warning the offending handover of the nuisance. Next, I will explain about the difference between public and private. A public nuisance is defined as an inappropriate, unjustified, unlawful interfere with the rights shared by the general public. Simply put, a public nuisance is an act that affects the public at a large or significant section of it, and it must infringe on rights that members of community may otherwise enjoy. The act that sensibly interfere with the general public health, safety, comfort or convenience or tend to erode public morals have traditionally deemed a public nuisance. For example, impeding a public way by digging trench is an example. Next, I will explain about the private nuisance. Private nuisance lawsuit element property. Owners have the rights to enjoy and use their land in the event that another party infringes on the rights. For example, a neighbor frequently blasts music at a maximum intensity late at night. Damages to property, physical discomfort and damage to property are examples of private anonyms. In this instance of property damage, any reasonable injury will suffice to support an action. That's all from me. Thank you so much.
Hi, I'm Felicia Francis. I'm going to talk about two articles that regarding nuisance. First article is Jamal Yunus has pleaded guilty to causing a public nuisance by smashing beer bottles in front of the Selangor State Secretariat building last year. He admitted to the charge under Section 290 of the Penal Code when he was taken to the Magistrate Court here for case mentioned today. Jamal, who was charged on May 25 while at a hospital in Ampang, was taken to the Magistrate Court today under heavy police guard. He had been in custody since last Friday when he was denied bail by the Ampang Magistrate Court. He had claimed trial to escaping from police custody on May 25 while in the process of completing his bail for several criminal charges. However, Section 9 of the Act specifies that nuisance is an act or omission which endanger the lives, safety, health or comfort of the public, obstruct the public in the exercise of rights common to all Her Majesty's subjects, or obstructs person from enjoying a lawful privilege connected with property. Second article. A liquor's ratepayer is at a loss to understand why City Hall has failed to crack down on a catering business being run from a home in Taman Fantasy. Towards the end of the October, he also submitted 2 letters to find out if City Hall had approved of the kitchen for the business being based in a residential area. The individual is listed in our register as having an eatery in the city, but this license cannot be used to run a similar business elsewhere in our rating area. It talks about how complaints on food nuisance have been filed against an at-home catering company that operates outside of Kuala Lumpur. One of the readers had submitted a complaint to the authorities and stated that he or she had encountered smoke emanating from the kitchen area of their neighbor's home due to the cooking activities. Thank you.
Hi, I'm Kosia Tamasan and I'm going to talk about article which is Stop Painting the Rainbow on Pigeon's Feathers, says SAM and Much Rabbit Nuisance at Ipoh Park. The reasons why we choose this article is it's related to our chapter 7 nuisance. First, I'm going to talk about stop painting the rainbow on pigeon's feather. In this case, people are not to buy the rainbow colored pigeons. It's described as a form of abuse. Pigeons have pigment all over their bodies. Selling pigeons colored paint on pigeon's feather for commercial purpose is a violation of pigeons' rights. The use of synthetic paint on their feathers had an impact on their natural environment of other pigeons that were not dyed. Applying chemical dye on pigeons is a nuisance process. The owner must be responsible for the welfare and needs to their animal under the Animal Welfare Act 2015 Act 722. In the fourth article, this is due to the fact that mud rabbits frequently gather there to participate in illegal racing, even during the day. Their activities are deplorable and a major annoyance to the parkgoers and nearby residents. They claim that the noise is unbearable. They are a nuisance in our neighborhood. They ruin the park's beautiful scenery and the noise from their motorcycle is unbearable. The mud rampant and their motorcycle were causing the disturbance in the sleep. And that's it from us. Thank you so much.